Hey there, I'm Louisiana estate planning attorney Paul Rabelais. I'm the author of the book Estate Planning in Louisiana. And in this video, I'm going to attempt to answer the often asked question, if I live in Louisiana, should I use a will or a trust as the vehicle for leaving my estate to my loved ones? So, tough question. We get it all the time. It's a tough one to answer for several different reasons. For one, everybody's family is different. Some people are single, some people are married, different families have different objectives. So not every family is the same. Also, what people own is different. Some people may just have a house and a bank account, while others have investments, out-of-state property, maybe a business. So that may play into it. And then another factor that plays into how you leave your estate is, quite frankly, the family dynamics. Sometimes there's the children may or may not have a great kind of relationship. Sometimes there's spouses of the children that right, wrong, or indifferent, they affect the estate settlement, or some parents want to leave things to their spouse or their children a certain way, or leave certain assets to certain children. All that plays into the overall estate planning legal program. In spite of that, I'm going to make my best attempt to answer the question, should you have a will or a living trust, as it's called, to leave what you have to your loved ones when you die? So the best way I know to answer that question is to give you two examples. So these are two couples. In fact, they live right next door to each other, and they live in Louisiana. And in one home, Will and Wilma live in that home. They've been married for many years. They have 3 children. And in the home right next door, by the way, lives Trent and Trina. They have 3 children. And both these couples, they have a great family. The family is important to them. They've worked hard. They want to protect what they have. They want to protect each other. They want to protect the children. They want to make things kind of as simple as they can. So they both have similar objectives, and they own who'd have thought they own the exact same thing. They each own their homes. They each own another piece of property or real estate. They each have various investments. They've got some CDs and bank accounts at the bank, and they've each got a couple of vehicles. Who would have thunk that those families would have been so similar? The one area where they differ, though, is Will and Wilma. They set up wills, leaving things to each other and then to the children. And they left everything in their names. So Will and Wilma's wills left their estate first to their spouse in some form. Maybe they left ownership to their spouse. Maybe they left usufruct to their spouse. Maybe they left their estate in a testamentary trust for their spouse. And again, a testamentary trust is a trust that's in your will, and more videos on that you can find. But nonetheless, all done through their will. And then, of course, both Will and Wilma provided that when the survivor died, things would go to the 3 children equally. And Will and Wilma had designated in their wills that their spouse would be the first executor, but they also designated their son Ed as the alternate executor to handle things after both Will and Wilma passed away. Trent and Trina, on the other hand, they formed a trust. They formed the Trent and Trina Living Trust. I'm being a little bit informal, with Trent and Trina as the trustees of that trust. And their trust says very, very similar in substance provisions to what Will and Wilma's wills said. In Trent and Trina's trust, it says that when one of them dies, the survivor has access to all of the trust assets for the surviving spouse's needs. And then it says that after both Trent and Trina pass away, their son, Travis, is going to be the successor trustee to make sure that assets get divided up equally among Trent and Trina's 3 children. Okay, so Will and Wilma had wills, Trent and Trina had a living trust. Next thing that happens on the exact same day, what do you know? Will dies and Trent dies. So they get through the funeral arrangements, and both families are in attendance at both funerals. And then it's about a week after Will died and Trent died, Wilma and Trina start talking. And Wilma says, looks like I'm going to have to call a lawyer and get round my kids up and go start the succession, because I want to sell the house. And my understanding, Wilma says, is I can't do it until I complete the succession. So I'm going to get my kids in from out of state. We're all going to go see the lawyer, start that process. And then when that's over, I'd like to sell it sooner, but I realize I can't. So when the succession is what we call it in Louisiana, when the succession is over, me and the kids, we'll sell the home, because Will had left Wilma the usufruct of the home and had named Will's 3 children as the naked owners of his estate, which includes his home. But then Trina, after hearing what Wilma said, says, well, Trent and I, we formed this living trust. And I want to sell my house too, to move closer to my son and my grandchildren, but I don't think I have to go through anything. So at that point, Wilma and Wilma's kids, they call the lawyer. They set up an appointment for a couple of weeks out. They meet with the lawyer. The lawyer starts preparing all of the succession legal pleadings. Maybe 6 months to a year after Will died, all good relationships, so no special issues there. The succession is complete. Obviously, there was some legal expense, probably what many people consider not insignificant legal expense, several $1,000s or more, for Wilma and the kids to go through that court-supervised process of taking Will's will, hiring lawyers, going through the court process, and getting judges to sign orders that Will's name be taken off of the title of the home, taken off of the accounts, and those accounts put into Wilma's name or Wilma and the children's names. Where those things that were in Trent and Trina's trust, they just stay there. The trust says that once Trent dies, Trina is the sole trustee, and Trina can use those assets as she sees fit and as her needs require. So she doesn't even have to call a lawyer, much less go in and go through a court proceeding, because things in a trust, they're not frozen when someone dies, and they don't have to go through a court process for the title to be changed. They just stay in the trust, and the trust instrument dictates who's in charge of those assets and what they can be used for. So after Will dies, Wilma and the kids go through a succession, takes several months, obviously several $1,000s. And then after Trent dies, Trina does nothing. She just stays in control of everything. In fact, she sold their house 9 days after Trent died, because she had the authority to do. She didn't have to wait on a succession to be completed. So now it's a couple of years later. Wilma and Trina have both sold their homes. They moved across town closer to their grandchildren in a smaller house where they wouldn't have to manage so much. And then what do you know? On the same day, both Wilma and Trina pass away. Funerals take place. A few days later, Wilma's son Ed, who is the executor of Wilma's will, goes to the bank to start dealing with some of Wilma's accounts, and goes to the investment company where Wilma had some investments. And both of those financial institutions, Ed pulled out the will and says, I'm the executor. I just want to divide this money up among myself and my 2 siblings. Ed's kind of shot down. He says, I'm sorry, Ed, your mother's accounts have been frozen. It's required by law. You need to go see a lawyer. You and your siblings go through the court process. Once you get the appropriate court orders, bring those back to our legal department at our financial institution. We'll take a look at those court orders, and if everything looks good, then we'll release the funds to you and your siblings. So Ed's like, oh, geez, I thought I'd have immediate access because I have a will, and my mom's will, and it says I'm the executor. On the other hand, Trina's accounts are titled in the name of her trust. So Trent and Trina's son Travis goes to the financial institution, goes to the investment company, produces a copy of the trust that shows that Travis is the successor trustee of the Trent and Trina trust. And the financial institution says, Travis, no problem, sorry for your loss. why don't we go ahead and set up 3 new accounts for each of you and your 2 siblings, and let's go ahead and transfer all of your mother's money and all of your mother's investments into those 3 accounts. We can do that today. Travis says, great, that's exactly what I was hoping for. And so really the difference there was Will and Wilma had wills where they left things to each other and then to their 3 children, naming Ed as the executor. And when each of Will, and a couple of years later when Wilma passed away, at each of those instances, the family was required to hire a Louisiana lawyer like myself, where we would, get the family together. All the people that are involved have to be, represented. We would gather all of the appropriate information. We would prepare all the necessary court pleadings. We would get all the appropriate signatures from all of the parties that are involved. We would file all of the pleadings at the courthouse, work with the courthouse and the clerk of court and the judge's office and their, assistants and clerks to make sure that everything was right and that the judge would sign the appropriate court orders. And then we'd start getting those court orders to the different third parties, the banks, the financial institutions, the Department of Motor Vehicles, title examiners, so that, title of all of those assets could be taken out of Will's name and into some arrangement where Will's name was not on there. Whereas with Trent and Trina, and their assets were titled in the name of their trust when Trent died, Trina didn't have to do anything. The trust says that when Trent dies, Trina stays in control as the trustee of the trust. She can do whatever she wants to with the assets. And so that probate, or in Louisiana, succession, was not necessary when Trent died, but it was necessary when Will died. And then at the second death, or at that surviving wife's death, when Wilma died, she had a will. She named Ed as the executor. She named her 3 children as equal heirs. All of Wilma's assets were frozen. Ed and the 2 siblings come back to the lawyer's office, start it all over again, gathering assets, preparing pleadings, getting the appropriate signatures from people around the country, filing the pleadings at the courthouse, paying the court fees, and again, having that, dealing with the clerk of court and the judge's offices to get all the appropriate, orders signed by judges. Whereas when Trina died, Travis didn't have to do any of that. He could sell assets that were appropriate to sell, such as Trina's home, and disperse the proceeds to the 3 children. And if there were assets that didn't need to be sold, bank accounts or maybe shares of stock, Travis could simply immediately disperse those assets out of the trust into the 3 children without having to go through all of the lawyer and court involvement that's required when you go through a succession by leaving things, from a will to heirs. So that should give you some idea what's best. It's up for you to decide. My preference is, enable you to make an informed decision, so you can make an informed decision. In our law office, we've done many wills followed by the successions or probate, whatever you want to call it, after the person who had the will died. And we've also done many living trusts where we didn't need to get involved upon the death of what's called the living trust settlor, the person who set up the living trust. So I'm not here to say that one is absolutely better than the other, but I really think it's important that you understand things. Maybe the biggest misconception people have, many people have told me, Paul, I thought that if I have a will, there wouldn't need to be any probate or succession. And that's probably the biggest misconception. What a will does is it names your executor, who will hire the lawyers to guide the family through the court process. And a will is going to tell a judge who to make sure that the assets ultimately get transferred to. But it's not a will that eliminates the need for the succession. It's the having assets in your name when you die that requires the succession, even if you have a will. So there's quite frankly, about 15 minutes worth of should you have a will or trust, will versus trust. So hope that gives you some guidance on maybe the path you may start consider taking when trying to protect what you have for your family. Keep 100% of what you have in the family the right way, providing for your spouse if you're married and your children, and